Hi, everyone. In this video, we will see about the Director under Companies Act 2013. 1. Statutory definition. 2. Type of directors by function. 3. Independent directors. 4. Special categories. 5. Appointment-based types. 6. Board composition and rules. 7. Disqualification. In the statutory definition, we learn about Section 234, de jure versus de facto directors, shadow directors, and officer under Section 259. A de jure director is an individual who has been officially and validly appointed to the board in accordance with the law. A de facto director is someone who assumes the role and undertaking of a director and purports to act as one, despite never having been validly appointed to the position. Functional focus. To prove someone is a de facto director, it must be shown they perform functions that are appropriately discharged only by a director. Corporate titles. The sources note that companies sometimes use titles like executive director or director marketing for high-level employees without officially appointing them to the board. Shadow and deemed directors. This leads to the concept of shadow director, someone who operates behind the cloak of obscurity, exercising strategic control clandestinely. Section 259. Officer. This definition is inclusive and covers any person whose directions or instructions the board is accustomed to act upon. Liability. Under Section 260, an officer who is in fault specifically includes these deemed or shadow directors, ensuring they are held liable for defaults despite not being formally on the board. Directors by function will be classified into two categories. 1. Executive director. 2. Non-executive director. Executive directors are those engaged in the active, full-time management of the company. Executive directors can be classified into two categories. 1. Managing director. 2. Whole-time director. Managing director, MD. Defined under Section 254. This individual is vested with substantial powers of management over the affairs of the company. The role is considered analogous to a chief executive officer. Whole-time director, WTD. Governed by Section 294. These directors are in the full-time employment of the company. While they hold significant operational responsibilities, they do not possess the same level of management power as a managing director. Non-executive directors do not participate in daily operations, but play critical roles in governance and impartial decision-making. Non-executive directors can be classified into two categories. 1. Independent director. 2. Nominee director. Independent directors. These are non-executive directors who serve to improve corporate credibility and governance standards. According to Section 149(6), they must be persons of integrity with relevant expertise and have no pecuniary relationship with the company, its promoters, or subsidiaries. Nominee directors. Appointed under Section 161(3). These directors are nominated by financial institutions, the government, or other stakeholders to represent and safeguard their specific interests. They often face a dual, conflicting role and must act in the best interest of the company. Thank you. Remaining we'll see in next video. Keep supporting and stay tuned.